We have now also joined, or rather we're now also joined by Dr. Sam Amadi, Executive Director of Abuja School of Social and Political Thought from Abuja. Dr. Sam, you're welcome. Thank you very much for joining us this evening. Like I said to Sagir, in the eye of the ordinary Nigerian, when they interpret the scenario, it's like as if the Senate is disobeying the court's rulings. Or is it the other way around? Is the court overstepping into Senate procedures or Senate processes regarding the reinstatement of Senator Akpoti-Uduaghan?
Well, thank you for having me. But I think there's already a general confusion around the jurisprudence of judicial review of parliamentary process in Nigeria. Some take the view, there have been cases in the High Court up to the Court of Appeal that suggest that the Senate does not, or the House does not have the powers to suspend or exit a member. But if you look at cases from across the country, the US particularly, where we share the same jurisprudence, I think that the parliamentary privilege includes the privilege and the power of the Constitution to self-regulate, and that includes deciding what offenses a member can commit and be thrown out or suspended. So I think there's no confusion as to the way the courts have approached it. In this particular case, the decision seems to be that the judge concedes that the Senate has the power to suspend a member, concedes that the Senate rules have legal validity, even above the Act, but gets to the point of saying that the length of time is too long, and therefore advisory the Senate should, and they should apologize. And it was not authoritative enough, and that's what's causing the confusion. So in my view, the Senate can still claim that it's not disobeying the law, especially as it has appealed, perhaps applied for stay of execution or whatever. Look, in good conscience, this matter ought to be resolved from the perspective of National Assembly, seeing reason to recall its member, and the member himself or herself seeing reason to belong to that body. There is a history of parliamentary privilege, meaning that the courts do not intrusively try to regulate, because the branch of government, those that have executive discretion, the president has the power to fire or hire. We saw what happened with Sanusi when the president fired him. People say, okay, that should due process. But essentially, the judiciary will likely say, this is presidential prerogative. As long as they do not violate the Constitution, they're right. And we see that in the US also with some of the decisions. So I think, in my view, that the court is responsible, first, for not clarifying its jurisprudence. Two, for making orders that are subject to confusion. There's growing obtuseness about judicial in Nigeria. They're never clear, they're not authoritative, and they're not allowed several self-help. So the Senate can see what Natasha is doing as self-help. Natasha can see what the Senate is doing as self-help. So it's this lack of clarity, and maybe it is intentional by the judge to be vague, that has created this crisis. So if I was advising the Senate, I could say that somehow they may feel that they are not bound to admit her in. And she might also feel that the court somehow says, my stay is too long, so I need to close it out and enter the house. So we're going to live with this stalemate, and perhaps the Court of Appeal takes opportunity to clarify what the law should be.
Okay. Mr. Sam, was Senator Akpoti-Uduaghan naive to have approached the Senate as she did today? And does that foreclose any amicable means of resolving this matter?
I think what she did was like self-execution, to say, I write to the Senate, I'm going to come tomorrow to resume my work. Maybe, in a sense, that's how she can force out an access, execute a judgment. I'm ready to do my work, my function, so let me in. But it will be seen like, I don't think any of the senators really are standing in it. And by the way, the Senate is a chamber for proceeding. I would expect that perhaps today a senator will move a motion and say, this is our member who has been out for long. It's now time to admit it. Senate will regulate itself. So in a way, she's now an activist. Maybe she will win this battle and usher in a new beginning of, National Assembly management. But for now, she's acting like an activist, not like a legislator, and doesn't seem to have any persuasion internally in this institution. So I think that those who are also advising her, those who want to facilitate help her in this case, should also find a way to create a constituency support base in the National Assembly, because really the Senate and the House self-regulates. And so if their members are not willing to regulate, to raise motions, to use their rules to let a member in, it might actually be very difficult to have an enforcement except through mob action and self-help as she's doing. So it's not a good strategy. It kind of creates opportunity for competition between the establishment and the individual. The right way would have been for the court to be more authoritative, and then for that to trigger some kind of parliamentary procedure for them to change their rules or to annul that ban or abridge it and let her in. I think that's ego. She doesn't want to apologize, and the other guys don't want to apologize. The issue of sexual harassment is not even in picture here. This is issue around Senate management of its rule, and my sympathy would go to the institution because that's what I'm taught in administrative law and constitutional law.
Okay. Is there any chance that the matter may settle or be settled, or rather settle for a political solution, as given that the judgment, well, as they say, is an arbiter?
I think it ought to be settled politically, basically, as I'm saying. The National Assembly is a political branch. That's why in typical jurisprudence of the U.S. Supreme Court and elsewhere, they talk about deference. They don't like to determine the proceeding or force Parliament to do anything because it's a political branch. And institutions are political. They can make a choice in how they like it. The judicial branch is bound on precedent. Now, I think that the political solution is actually the best. In this case, it just relies on the members themselves to say that this drama is distracting, this is not good image for the National Assembly. Because anyhow you look at it, you might be more powerful than Natasha, but you are losing more reputation than she is. The National Assembly as an institution, the Senate President himself, they have been tarnished. And they continue to be tarnished as long as this drama, this circus is on. So why can't there be up to 10 senators who walk into that chamber and say we can foreclose all this? I think perhaps she has learned her lesson. Perhaps she will go and sit at the seat where she's assigned to. Let's be very clear. She has no right to refuse to sit where she's assigned to. The Senate President has authority based on the rules to assign seats. So she has to go back to her seat. Then we have to bring her back to Parliament under that truce. And again, it means that she has to be less belligerent. I mean, if you're going to fight the institution, say, to death, the institution has a right to defend itself to death. That's the problem. And so there must be a curtailment of ego on both sides. She has to accept some fundamental truth. One, that sexual harassment is a matter for criminal prosecution. She can take that up. It has nothing to do with Parliament and her process. Two, she has to accept that the Senate rules, as used by the Senate President, is a rule that binds her and every other person. It might be dictatorial. It might be too much power on the national and the president, and I think so. I think that we have turned the National Assembly to some kind of executive office where the Senate President looks like a president. No, let's borrow from the U.S. where we are borrowing from, where the Senate leader, where the leader and majority of minority leaders or the speaker themselves do not act as if they are executives. This is a deliberative chamber. So the Senate has to look back at these rules and say, do these rules make for effective deliberation? Is it a rule of an executive branch where there's a Senate President who has a lot of vehicles, who lives big like a president, who rides on Air Force One? That's not the idea of a parliament.
Mr.
The
Amadi.
idea of a parliamentary rules are rules that enable effective deliberation.
Now,
so
Mr. Amadi, my apologies for cutting in there, but we're almost running out of time, and I really wanted to know, now referring to the judge's ruling as obiter dictum, doesn't that put the court somewhere against the Senate? Now, this is going away from being a situation between Natasha Akpoti-Uduaghan and the Senate President. It's now becoming something more of the judicial system against the Senate. I don't know what your take is.
I think the Senate's obiter is even complimentary. I think it's really neither here or there. I mean, look, the case is simple. If she says her suspension is unconstitutional, it's either yes or no. It's not advisory. So if you maintain that the Senate has the right to suspend her, then I would argue that it means that the Senate can suspend her for that long length of time. For me, that's a constitutional logic. The question then is, does it contradict her commitment to represent her people? At what point can, because in the U.S., the Senate has also, the legislature also expel members that are members who have been expelled through a process, due process investigation and votes. So it all depends on the process they adopt. That's why it's called a deliberative chamber. They have prerogative over votes. So I think that the court caused this problem. And this is not the first time we've seen the Supreme Court do the same thing with PDP. Maybe they will justify their logic, but for me as a legal scholar and a critic, I think the court's tendency to prevaricate, to speak on both ends, to not really come down on yes or no, gives opportunity for litigants, the Senate, to choose what to interpret. So the Senate says it's obiter. Yes, we know the obiters are not binding to lower courts, but obiters themselves ought to be respected, their opinion of judges. But really, when people are fighting for right and wrong, something substantial like this, you can't make a strategic decision based on opinion, obiter. The question is, did the judge declare her expulsion or suspension unlawful? If it's not beyond the power of the National Assembly, then it means it's lawful. But the question of ethical, the question of whether it's reasonable, appropriate, are questions that, at the public opinion, we can discuss. And so I think that the National Assembly may not be really beyond the normal institutional right that they exercise to say, we are not bound to accept you by the court. Otherwise, let the court show us. And both parties have gone on appeal, in which case they are asking for a more authoritative decision. And I think perhaps this is a case that the court appeal can take quickly and give a decision and say it is legitimate, it is not. If it's legitimate, then let's explore political solution. In which case we can say, people from Kogi can say, we want our legislator back to make rules for us. And then the Senate can go through a process to make decisions. So I think the senators themselves should rise up and defend their institution from this ignominy. Let them foreclose this quarter, bring her back on the terms that fit with the rules, which is she takes the seat assigned to her by the Senate President, who has authority to prescribe seats.
Well, Dr. Sam Amadi, let me say thank you for that masterclass in the law as regards the Nigerian legislature. Thank you very much, sir.